I'm Michael Harvey, the Information and Privacy Commissioner for British Columbia. In our latest report, we joined the Office of the Privacy Commissioner of Canada and our colleagues in Alberta and Quebec to look at how OpenAI collected, used, and disclosed personal information to develop its AI-powered chatbot, ChatGPT. We examined OpenAI's compliance with our respective privacy laws. In our case, BC's Personal Information Protection Act, or PIPA. We assessed OpenAI's collection, use, and disclosure of personal information with ChatGPT against the privacy protections our legislation provides the people of our province. What we found was that OpenAI contravened PIPA in all but one of the 13 issues we investigated. To initially train ChatGPT, OpenAI scraped vast amounts of personal information from publicly accessible websites. This was as widespread as it was indiscriminate. Social media, discussion forums, blog posts, news outlets, and more, whether from a child or an adult. All of this information was obtained without the knowledge or consent of people living in British Columbia or others whose personal information was captured by such scraping, and it goes against PIPA. I am very encouraged that OpenAI has taken positive steps to improve their practices, including retiring the initial ChatGPT models we investigated, introducing filtering tools, changing some of their data practices, and committing to compliance reporting. As a regulator, I must note, though, that the core issue remains unresolved. This report speaks to a fundamental disconnect between how one of the world's most popular and widely used artificial intelligence applications works and what our privacy law and the principles that underpin it demand. It highlights how far we need to go to create an environment where trustworthy innovation in AI can thrive, and it shows the extent of changes we need, both from innovators and from our laws, to make that happen. We're left at an impasse. Yes, AI applications have potentially transformative benefits, but in certain cases, such as the one at hand, the applications were developed without adequate privacy consideration. Those privacy laws were written for a different era and are strained to the breaking point when it comes to considering new technologies like AI. Both have to change. I'm encouraged by the direction that OpenAI is headed and will be monitoring progress carefully. But monitoring is not enough. We need a modern privacy law to respond to a landscape transformed by AI. I have written to BC's Minister of Citizen Services urging the government to act without delay to modernize our legislation to respond to today's challenges. This doesn't mean removing guardrails as this powerful technology races ahead. The opposite is true. It means putting the onus on organizations to earn the trust of the people whose data they use. We need an updated law that allows for innovation while upholding the requirement for people to know about and consent to the collection and use of their personal information. We need to start with consent. But where that is neither feasible nor appropriate, we need other legal authorizations in PIPA that come with strong guardrails, robust independent oversight, and the burden for compliance on the companies profiting from the use of people's data. The goal is a British Columbia where companies innovate and compete on how to empower people with control over their own information. Ultimately, the principal beneficiaries of the use of personal information must be the people to whom it belongs. We need to make sure that AI works for us, not the other way around. This is how we can lay the groundwork for trustworthy innovation. This report makes clear just how much work we have ahead to make that a reality. I encourage you to read about the report by visiting our website at oipc.bc.ca.